Donald Trump verdict issued by the jury, and it's split. A lot of people in the media doing cartwheels, very excited about some of the counts, but E. Jean Carroll lost the big one. The first one, the one with the big R, the one with the insertion of the thing in the other thing, you know, the one we're talking about, didn't win that. Donald Trump found not liable. And this begs the question, very curious, why did he get found liable on other charges, but not on the big one? If E. Jean Carroll is so credible on the other charges, why didn't they believe her as to the big one? So we are going to go through this in detail. We do have the verdict form, which was checked off by the jury. We'll go through it in detail. But we're also going to ask ourselves, is Donald Trump going to appeal this? He did post a couple things on True Social. We're going to go through the trial proceedings, courtesy of Inner City Press. And then we'll ask ourselves about a framework and 7 reasons or 7 areas that might be appealable that have already been articulated for us, courtesy of Joe Tacopina. So let's start at the top. What happened? The jury came back and issued the verdict form. This is what the judge received. We will go through the proceedings in a short minute. But here, page 1 of 4, filed on May 9th, 2023, E. Jean Carroll against Donald Trump, the verdict form. And this was the big one. You know that E. Jean Carroll and her plaintiffs team, Roberta Kaplan, they're sitting there waiting for this to be read. And the media is waiting with bated breath. They're just, they can't wait. Donald Trump is going to be the first president ever. And then the question comes. The clerk of the court reads, did Miss Carroll prove by a preponderance of the evidence that Mr. Trump raped Miss Carroll? Answer, no. Now, you're not going to see that headline all over the place. Instead, you'll see the opposite, which is this one, which is the lesser of the two. Did Mr. Trump sexually abuse Miss Carroll? Answer, yes. Now, we get to skip over question 3 because of the yes answer on 2. We jump to number 4. Was Miss Carroll injured as a result of Trump's conduct? Answer, yes. What are the damages? $2 million for the grab. So you can see a little bit of a separation between the two. They believe there was some physical conduct. They believe Trump was there. They believe Miss Carroll was abused and that she was injured, but not that injured, not the old thing. This was interesting because Miss Carroll testified to this at length. So I didn't scream, but I know what happened many times. So why is it that the jury believed her on this, but not this? Jury says you're not credible on this charge, and you're not credible. The phone call that you reported is not that credible to everybody. Not raped, not liable for that. Was Mr. Trump's conduct willful, wanton, reckless? Yes, it was. And how much in punitive damages? $20,000. That's it? $20,000? What? That's like tip money, man. That's nothing. Trump's got $1 billion. Billions. That's punitive? So they don't even think it was that bad. They're like, all right, yeah, maybe it was like a hard grab. And so compensation for this injury is a lot. You know, nobody wants to be grabbed anywhere, probably, most people. So that injury in and of itself is $2 million, but only $20,000 for punitives. And punitives are usually even worse because you compensate somebody and you punish them for being a bad actor. How dare you? So my question is, why is the jury just giving him a little slap on the wrist? $20,000 on $2 million? It's nothing. Trump has that under his seat cushion. So I think that means what we can extrapolate from this is that they don't think that Trump should be punished all that much from this. It's just $20,000. It's like nothing. It's a rounding error on $2 million. It's probably transaction fee. So it's not that punitive at all. In fact, the jury almost, you could make the argument, is not punishing him hardly at all as a percentage of the total judgment. So, all right, that's it. I guess that's the big verdict that they're all so excited about. Donald Trump's the first president ever found liable for sexual abuse of Miss Carroll. The jury didn't really believe it all that much. Yeah, I mean, they gave him $2 million, okay. But then at $20,000 in the punitives, whatever. Anyway, so we move on. Now there's now that one's out of the way, now that they say the thing sort of happened, E. Jean Carroll's sort of credible. She said all of it happened, but we think only part of it happened. So she's kind of a liar. There's not enough evidence to support all of her claims. So we'll just sort of split it. Now, why would they do that? I think I can think of a few reasons. I'm sure you can. But one might be because Trump admitted in the deposition that you can kind of grab women by their purses sometimes, especially if you're a celebrity. They just kind of let you do it. And so he's acknowledging that, maybe I do that. That is conduct I will admit to, but I didn't do that in this particular incident. And they don't believe that. They say, well, he admitted to doing that previously. This judge allowed in Jessica Leeds and other people to come in here and Natasha Stoynoff and testify about what Trump did to them. And so they may just say this is evidence that he is acting in conformity with prior patterns. And that's how they justify this. Well, he's got no history of the R, but he does have a history of grabbing them by the purses. And so sexually abusing Miss Carroll is sufficient. And the damages is $2 million, but punitives, not so much. So now that that's out of the way, we've got Trump's statement being defamatory. They say, yes, since you did grab her by the thing, you said you didn't do it, therefore it's defamatory. Did they prove by clear and convincing evidence that the statement was false? Yeah. Did they say that Trump made the statement with actual malice? Yeah. And was Miss Carroll injured as a result of Trump's statement? Look at this. Trump posted apparently one statement on October 12th, 2022. Carroll was injured as a result of the defamatory statement. How much was she injured? Wow, $1 million. Wow. So one post on a social media company is equal to 1/2 of a purse grab. I think that's the conversion rate. Is that right? I'm pretty bad with math. Damages other than reputation repair. If yes, insert a dollar amount for any damages for the reputation repair program only. Whew. Another 1.7 other than and another one. So that's 2 plus 1 plus 1.7 plus another 280 is going to give us the total $5 million. Wow. So one post is more expensive in damages than a grab of a purse, of E. Jean Carroll's purse. Post was worse than the purse grab. That is an expensive post. So I think what this is saying is it's almost as though Trump is being penalized more for posting than he is for grabbing anything, just based on damages. 2.7 million versus $2,020,000. So the illegal post was worse than the purse grab. Now, in making the statement, Trump acted maliciously out of hatred, ill will. Did he? Jury says yes. And punitive damages for the post are at $280,000. So the grab was worth $20,000. The post was worth $280,000. All right. Well, I guess you know what is valuable in this verdict. All the jurors who signed off on it, 10, 37, 39, 44, 48, 58, 77, 80, and 81. And that, my friends, is the verdict. Now that came after a day of proceedings, which we will take a look at. But first, Trump said in reaction to the verdict, posted this soon after it came out, said, "I have absolutely no idea who this woman is. This verdict is a disgrace, a continuation of the greatest witch hunt of all time," was his immediate reaction. Now the day's proceedings started a little bit on the same tone. Trump posted this bright and early, 6:39 a.m. before the proceedings started. He said, "Waiting for a jury decision on a false accusation where I, despite being a current political candidate and leading all others in both parties, am not allowed to speak or defend myself, even as hard-nosed reporters scream questions about this case at me. In the meantime, the other side has a book falsely accusing me and is working with the press. I will therefore," Trump says, "not speak until after the trial, but I will appeal the unconstitutional silencing of me as a candidate, no matter the outcome." So that is a hint starting the day that this will be appealed in some way, shape, or form, and that Trump will not continue to stand by. Now, there will be further justifications for an appeal, which we will come back to, but let's see how the day's proceeding started, courtesy of our friend at Inner City Press on Twitter. And all of this documentation, all of this material, along with links to everything, is also on the Trump mind map at spotlightlawyer.com/Trump, where you can hop on here and get access to all of these materials, including links to the documents. But now we go to Inner City Press. He's reporting on this from the scene. He says that bright and early in the morning, 7:13 a.m., about 10 o'clock Eastern time, the jury enters. And the judge is picking this up, giving them the instructions. Yesterday, we had the jury charging conference, and we were going through the finalities of the rules. Now the judge is going to be explaining them to the jury. Judge says, "Ladies and gentlemen of the jury, in the course of my instructions here that I'm about to give you, I'm going to explain the verdict form," the one that we just read, "and the burden of proof, and my final words to you will be with respect to the conduct of your deliberations. He lays the background. He says E. Jean Carroll is suing Trump for money damages. We know the event happened at a department store. Allegedly, it was in the lingerie department. The pair went to a dressing room. Trump then pushed her against the wall, kissed her without her consent, allegedly. Mr. Trump denies this ever happened. The second claim concerns a post on social media. Ms. Carroll says it was false and defamatory, and Mr. Trump denied that it was false. 2 weeks ago, I told you the first claim is for battery, and under applicable law, any penetration makes it part of the elements of the alleged battery. It qualifies. If you think there was any penetration of the thing by the other thing, it's part of the elements, then it qualifies. They didn't believe that. If you find that Ms. Carroll has proved it by a preponderance of the evidence, then you answer the question 1, yes. But guess what? They didn't answer that question yes. They answered it no. And it also shows you that this is a much lower standard than in a criminal case. Preponderance of the evidence means if it's more likely than not, the numbers we use often is 51%. If it's 51% more likely than not that it is true that Trump is liable and did this thing, then you got to find him liable. So they couldn't even prove this in a civil case. That's how weak this is. Meaning they would never prove this in a criminal case because this evidence standard is way lower than the criminal standard, which is beyond a reasonable doubt. Preponderance of the evidence. They couldn't even win on that one. It says under a different theory, the contact may be the actor of the victim. The law doesn't define which parts of the body are intimate, so apply your common sense. Use your own societal norms. Says gratification is subjective. The judge says, forgive me a minute. I got to get a drink of water. All these sex words are making my mouth dry. He says, okay, we're back. Forcible touching occurs when a person forcibly touches the intimate parts of another person for the purposes of degrading and so on. He says, if you get to question 4, we're talking about compensation. And so if you write $1, that's nominal damages. And he talks about punitive damages. And he's talking about the various claims and about damages. He says $1 is appropriate. You could put $1 on there if you say that there was no injury. He says, now I know you're ready to get up and do your job, but I got to explain the burden of proof. It's called preponderance of the evidence. Ladies and gentlemen, you must not draw inferences from comments I made to any of the lawyers. And this was ridiculous because this judge was making a ton of comments to the lawyers, telling them, move along. We can all do math, Mr. Tacopina. Is this necessary? He was vouching for Miss Carroll when she was hinting quotes out there. He's like, oh yeah, that writer from the 1700s. And she's like, yeah, Judge, that's right. He's like, well, that's a great answer. And they were doing this little game of patty cake this trial. Or when I took notes or used my computer, don't look at me. So he says that I'm going to fix all of my inappropriate behavior with just a little instruction here at the end. There was evidence received at this trial that Ms. Carroll says shows Mr. Trump assaulted other women, Ms. Leeds and Ms. Stoynoff, which he allowed in, shockingly. A different definition of assault applies to that evidence. You also heard evidence about an email from the Law and Order SVU issue that we talked about yesterday. It was not offered for truth, so you can't know about the episode, but you can only consider reaction. The judge says, listen, ladies and gentlemen, I'm a trial TV show addict, okay? And many of them are wrong. Direct evidence is testimony by someone who saw, or in my last trial, tasted it. He's being funny here. It was a trial about beer. He says, you're due to retire to deliberate shortly here, jurors, and your answers to each question must be unanimous. Discuss and weigh your opinions. Any notes you may have taken are for your personal use only. All 9 of you need to be present to deliberate. And so when you reach a verdict, you got to write a note, put it in a sealed envelope, and let me know. Don't add any commentary. It's a problem if you put it on there. There's been some media coverage of this case. Hopefully you have not partaken in any of it. You are totally insulated. Nobody knows who you are. I know you're going to render a fair verdict. Any objections from anybody? No. Now we're back. Judge says, and also, the reference to the written statement of Mr. Trump, I'm striking that. He says, you saw deposition testimony. You're entitled to access that. It's 11:45. I think we'll give him a break. Now, you'll stay here in the courthouse with your lunch. You're not going anywhere, jurors. Between 12:15 and 1:30, if there is a note or a verdict, there may be a delay. You're going to have a clean laptop in the jury room. You're going to have the exhibits. Take your time. So he says, judge says, okay, swear the officer. Mr. Marshall comes in. He says, ladies and gentlemen, you will now be retired and deliberate. Now, they're on a lunch break. Apparently, the lawyers are still in there. They're discussing Eric Trump's post, which is on spotlightlawyer.com/Trump, day 2, I believe that was, and Trump's post on True Social as well, which was also posted on day 2. Those posts are still up there. They're referencing these 2 items. This is the Trump mind map. Remember, on day 2 in the morning, he posted 2 tweets. It was before trial started, I believe, and Eric Trump posted this one as well. They're still up and posted. And Roberta Kaplan said, Judge, we got to do something about this. I don't like those things being up there. So now they're talking about it. Tacopina says, well, the most recent post, I guess that he probably posted this morning, that doesn't require any instructions. And he says, yeah, I agree with that. The judge says, yep, no further instructions. Tacopina says, anyways, I'm more concerned about lunch right now. Can I go to the cafeteria? The judge says, hey, you can even go outside if you want. He says, well, coming in here is so much fun. I'd rather stay in. So they have a break. We get an update. The jury has reached a verdict. The note comes into the courtroom. E. Jean Carroll is seated at the plaintiff's table. Tacopina is pacing around the courtroom, drinking bottled water by the defense table, slurping it down. Stay calm. Now, he sits down. Jury is coming in. All rise. Please be seated. Judge Kaplan speaks. Ladies and gentlemen, welcome back. I received a note reading in its entirety, verdict. We are going to move forward with this, and I want to remind everybody in the courtroom that the decorum will be maintained. There will be no shouting. There will be no race for the door. All you people in the media, those are things that must happen in here. It will be orderly. Everybody's nodding. Yes, Your Honor. Bring in the jury. Now the jury is entering. They walk in front of E. Jean Carroll's table and march back to the jury box. They come out with an envelope in hand. Judge Kaplan says, please pass that to Andy. Thank you. Andy walks over, grabs the envelope, brings it back, hands it to Judge Kaplan. He opens it up, flips through the pages one by one, reads through the different check boxes that we already reviewed, takes a deep breath, and says, handing it back over, clerk will publish the verdict. The clerk takes the document and starts to read. She says, as to battery, did Miss Carroll prove that Mr. Trump raped Miss Carroll? Answer, no. Audible gasps in the courtroom, maybe. I don't know. But I can tell you this, at the plaintiff's table, they're not happy about that one. That first one just dropped. They go, oh, what? Huh? Roberta Kaplan's not happy about that. E. Jean Carroll's not happy about that. Not at all. Now they're going to tell you they're happy about the next one, but that one, no. That should have gone the other way for them. And don't let them sneak away from that. They wanted Trump to be guilty of the big R. Didn't get it. Next question. Did Miss Carroll prove that Trump abused Miss Carroll? Answer, yes. Amount $2 million. We got that. Wanton disregard, yes. $20,000 for punitive damages. Laughable. Defamation, yes. False statement, actual malice. We saw all the rest of them. Now, Tacopina wants to poll the jury. They do. Jury is polled. Is this your true and accurate verdict? Yes. Judge Kaplan says it is confirmed and it will be filed and recorded. Ladies and gentlemen, jury service is a bedrock here, and I suggest you don't identify yourselves. Your transportation is ready. Jury leaves. Judge Kaplan says, good job, everybody. Trial is concluded. Now, we, of course, will see what additional filings are in store. We know that we have one of them that was laid out for us previously in this trial that helps to answer the question about whether Donald Trump will appeal this. We're going to review this. We already read through this entirely in a different video. And so if you want to watch the full document, I refer you to that video. This is what was outlined for us previously, submitted earlier in the trial after things started to go a little bit awry. Filed by Joe Tacopina. He listed here, you'll notice 7 different items, 1, 2, 3, 4, 5, 6, and 7 of them, that all might be appealable issues, and he put this anchored in early on in the trial to establish the foundation. And as a recap, he says, we respectfully submit this letter on behalf of Trump. We should be granted a mistrial right now in the middle of trial. This is all going to be carried over into an appeal for a few reasons. 1, the court mischaracterized evidence in favor of E. Jean Carroll. We saw that multiple times. Bolstered the testimony of E. Jean Carroll, vouching for her, allowed E. Jean to testify about different tables of lawyers, saying Trump's got a bunch of lawyers, and didn't acknowledge that she's got a whole bunch of lawyers. It's harmful to Trump's team. Continuously sustained improper argumentative objections. Permitted the testimony of Natasha Stoyanov without any voir dire, clear that her testimony doesn't fall within the rules and should be excluded under 403. It's too harmful. Did the same thing with Jessica Leeds. Alluded to the potential use of the statutes as a form of remedy for posts, essentially implying that he was going to refer Eric Trump's posts to the DOJ for interfering with his trial, showing clear bias by the judge. And number 7, expressing distress with Trump's counsel for bringing to its attention that somebody on their side, E. Jean Carroll's side, violated the court's protective order while not being concerned at all for Trump's rights. And that was back on May 1st. This was just a short list of all of the problems that we saw in this trial from the beginning. And this list has doubled, tripled, quadrupled since the trial moved forward. So if Donald Trump decides that he is intending to appeal this, he's got a bunch of stuff to chomp into, and I'm sure that he will. And of course, we will continue to cover this. We'll see what else happens with Trump. There is a lot more to come with his various prosecutions because this has been part of a plan to bog him down in litigation, to sideline him with criminal prosecutions, and we'll see where it goes. But today, in spite of what might feel like a major loss for Donald Trump, if you read the headlines, I think this was a pretty big blow for them. This shows that E. Jean Carroll was not found credible by the jurors on the first count, and also that the damages or the actual grab of the assault, the punitive damages were minimal compared to the actual damages, and the whole thing, the whole physical altercation was less serious in terms of money damages than the actual post. Kind of an embarrassing verdict. They should have come out of this with $50 million in punitive damages against Trump and guilt on all of them, liability on all of them, and they didn't. In New York City, with a judge who gave them no favors at all, in a deposition where Trump didn't do himself any favors, and the preponderance of the evidence standard is way lower than a threshold of a criminal standard, and he still walks away with a verdict like this.